My background is for 17 years I was a defense attorney representing employers and insurers. In May I switched and now I represent injured workers. So I have a bit of a unique perspective in that I've been on both sides working with you. Some of you probably worked with me as a defense attorney, and hopefully I didn't piss any of you off too much. And I've now worked with you, or some of you on the other side as well. So Mike asked me to speak to my experiences on both sides, given that not a lot of people have been in that boat. I'm sure all of you know what the responsibilities are of the QRC, but one of those responsibilities is communication. And the communications vary, and with regard to communications, at the beginning of the case, when I would come on as a defense attorney, I tried to notify you of my representation. I don't know that that always got out, but it was standard for me to notify you. I would request a copy of your file, and a lot of that was because that's where I got the background on the case, especially your initial rehabilitation reports. They had a lot of information that the defense wouldn't always get. A lot of times my file from the various insurance companies would be 2 or 3 pages. So it was your file that I looked to get the background. Now on the petitioner side, it's still the same for me, where if you are already on the file or on the case, I want your file to know what's going on, because I'm learning that my injured worker clients perhaps aren't always the best communicators, or at least with the most pertinent information. So with regard to the communications, Mike asked me to go through what did I like, what don't I like on both sides. As a defense attorney, one of my biggest pet peeves was when I wasn't CC'd on emails. I believe the rules require you to CC all the parties on any communication, which includes an email. There would be times when I would be added later, and I would happen to scroll down and see that I wasn't in there, and that was a huge red flag. Frankly, excuse my language, just pissed me off that you weren't including me, and it made me think, why aren't you including me? So I think that's key, to include the defense attorney, the employer and insurer, the injured worker, the petitioner's attorney on all your communications. As a petitioner's attorney, one of the things that I'm noticing frustrates me is if I'm not getting the update on the medical appointments. And I don't expect you to notify me that day. If I can get it the next day, that's great. I really do appreciate it. And I'll talk about this a little bit more too, with regard to the communications. If you don't want to CC all the parties, just pick up the phone, because I understand that's going to happen too. It happens on both sides. But if you're going to send an email, I think you need to include all of the parties. Because otherwise then I call Mike Hill and say, well, why am I not being included on this? And is this something I should be raising a red flag about? With regard to the prohibited conducts, I don't necessarily think that I encountered any of these, but Mike asked me to include this. So here are some of the prohibited conduct, which includes requesting or reporting information not directly related to an employee's rehab plan. I guess as a defense attorney, that would be when I would scroll down and see these emails where there would be communications like maybe directing the employee not to go to work, or things that just seemed like a red flag to me. This is just the rule on that it is required that you include all parties on any communications, including the emails, rehabilitation reports, any of that. Like I said, if you don't want to include someone, just pick up the phone or answer the phone when I call. Mike also sent out, or spoke with some people about what as a QRC are you encountering. So we included some of those in these presentations. So these are just some of the questions or comments that came about. Requesting the QRC to contact the injured worker and treating physician within 24 hours of the referral. I suspect this is something you get from the insurance company. Yes? That's exactly what I was going to say. But I believe, and I've seen it frankly from some of my insurance clients, that you would get the referral, and they would say, you know, you have to contact the injured worker and treating physician within 24 hours. And as you know, and as was just stated, you can't contact the treating physician until you have written authorization from the employee, including that authorization. So if you are being asked to do that, my recommendation would be just to tell the insurance companies that you can't. Although I know that I've seen it where they have their requirements about the 3-point contacts and all of that. Another thing that came up was the QRC being asked to contact the injured worker the day of their medical appointment to remind them to attend. In my limited research, I don't think they can require that you do that. They can certainly ask. I don't think there's anything that says they can't ask you. If you are doing it, I'd certainly bill your time for it. In thinking about it, to me, it seemed like in this day and age it may make sense just to remind people of their appointments so that you're not driving there and they don't show up. But again, I don't think that it's anything they can require you to do. Another one that was on quite a few of the submissions Mike had was, do defense attorneys have a favorable impression of QRCs and the function they provide? I think that depends on who you ask. In general, I think the QRCs were really helpful as a defense attorney. Like I said, your initial rehabilitation reports were really informative to me. I also appreciated the monthly updates because a lot of times I simply wouldn't get the information. So I did appreciate that. I'd be lying if I said there weren't some times where it was very frustrating because I felt like there absolutely was some bias.
We had a question from the chat.
Okay.
I wanted to know if you could repeat the questions that are being asked because they are not hearing it.
Okay.
And then they also asked if they could have your contact information.
Yes, of course. Do we have it at the end, Mike? My contact information will be at the end. If you're standing at the microphone, do I have to repeat it too, or do they hear that?
Yes.
Still repeated?
Yes, repeat.
Okay, sorry. The question was, can you have my contact information? And yes, it will be at the end. And then also that I repeat the questions, and I will try to do that. And also the question was, if I have a family member who would become injured or ill, would I suggest a QRC? And absolutely. I think that workers' compensation is confusing. Frankly, I've done it for almost 20 years, and I still am amazed by some of the things that come up. So I personally, yes, I would recommend that. Activities of the QRC, which I think hinder and or help a resolution of a claim, for me, and I think this is on both sides, it's the lack of communication. I'd rather you over-communicate with me. That being said, I understand you have a lot of cases, so I don't expect that you're going to update me every day, every week, every month, just when something pertinent comes about. Honesty, for me, is the best policy on both sides. If I was the defense attorney, tell me, like, this person's legitimately injured and they are going to need a significant amount of medical treatment, and or maybe you can tell early on this is looking towards retraining. I would want to know that because, frankly, I need to let my clients know, and we need to factor that into reserves. That's huge on the defense side, is what are the costs going to be? So the more we know going into it. But I would say the same on the petitioner side. I want to know. You're in there with those appointments, you're hearing what the doctors say. It's helpful for me to know what they're saying. So those are activities in general that I think hinder and or help. I don't think you're doing the injured worker any good if you're not sharing what you know as far as what's happening at those appointments or the direction you think the claim could be going. What are attorneys' current thoughts and positions regarding the value of job placement? I think there is a whole panel on job placement later, so I'm not going to spend a lot of time on this. But in general, I think it depends on the injured worker. I think some people really want to get back to work, and for those people, job placement can be a great service. I think some people just really don't want to go back to work, and I'm also learning as a petitioner's attorney, they don't like you when you tell them they should go back to work. So I have to work on my delivery a little on that. But I think it can be a really great service. I think that the help with the resume and helping get job leads and that, I think it can be beneficial for the people that really want to go back to work. With regard to the QRCs, neutrality for me is huge. A very smart person I know told me that a good QRC is going to be neutral and the pendulum is going to stay in the middle. You don't want it going to the left or to the right. And the QRCs that I am now reaching out to as a petitioner's attorney are those that I felt like worked with me genuinely in a neutral perspective on the defense side. I understand that that can be difficult, and certainly if push comes to shove because you are dealing with the injured worker more, I think that's probably where it goes more so. But the neutrality is key. Some examples on the defense when I felt like I wasn't getting a neutral QRC was when they would get released to return back to work without work restrictions, and I wouldn't find out till a week later. And that did happen, where I would get the email a week later that they'd been released to return to work without restrictions. In the meantime, my client's paying for wage loss, temporary total, whatever it may be, and if that happens, they get very mad at me. So it didn't smell right. It didn't pass the smell test for me. Similarly, and I understand you can't be involved in maximum medical improvement, but if that was discussed in the medical records or something, I think it's something you could at least put in the summary of it. So not sharing that information. On the petitioner side, it again goes back to the communication, but if I'm not getting accurate information about what happened at that medical appointment, and or if you're sharing information with the insurance company and not me, it makes me feel like maybe you're hiding something. So that open communication. These are just the rules on neutrality. You have the responsibility to remain professionally objective in conduct in all recommendations on the case. With regard to the objectivity, I didn't realize this until looking through the materials and trying to prepare for it. Certainly makes sense to me, but the QRC has to disclose any contracts that you and or your company have with the insurer. So if it is a QRC company owned by an insurance company or some affiliation, you do have to disclose that to the injured worker and or all business referrals. So going back to some of the information that was provided to me as far as questions that you have, many insurers fail to understand a QRC is to be neutral, so they'll request QRCs to assist in claims investigation, get records, provide specific questions to ask doctors, provide specific questions to ask the injured worker. So obviously, you have to remain neutral. You do not need to provide the doctor with specific questions that the insurer is requesting. That being said, if the employer has light duty work available, you have a duty to let the doctor know about that. You certainly don't have to ask about maximum medical improvement. You are not the go-between. I'm sorry, I'm going to rephrase that. You are not at the insurer's beck and call. You have your rights and responsibilities. Obviously, you are all far more experienced and experts at that than I am. That being said, I certainly, as a defense attorney, I'm sure you probably got emails from me where I asked you to do things and you were like, no, we don't have to do that, and that's fine. I certainly responded when people said that. Sometimes I was of the mindset that it doesn't hurt to ask, and then, and then you would tell me that I was completely out of line. Let's see, insurers will get upset with QRCs who copy employee on all email communication they receive, including the insurers, which obviously the rules require you to do, so if they tell you to do that, tell them to bug off. They tell you not to forward the insurer's email to the parties. Again, if you're included on that, you have to share that with all parties in our prior discussion. Insurers appear to look more upon QRCs as assistant adjusters to help get records for them, schedule employee medical appointments, et cetera. Generally, it is not your job to schedule the appointments. This also I learned from Mike. I thought it was. Apparently, it is not. You can assist with it, and if the injured workers can't do it, it is certainly something that you can assist with. But that was news to me. I didn't know that. As far as obtaining medical records, again, it is not your job to secure medical records. It is certainly helpful when we get the records, but it should be only those records relative to the injury. I did not know this, but apparently sometimes you're asked to get records for IMEs and unrelated to the injury. That is not your job. That is the insurer's job. If a registered QRC is acting as a DCM, they will have the DCM work the employee when it's known they won't return to work with the same employer until an FCE can be scheduled. and/or DLI finally sends the insurer a letter that they must have a rehab consult. And I'm not seeing, I didn't see this as much after the rules changed about not being able to be a disability case manager in a QRC. I don't know if that's, apparently it must still come up a little because this was submitted. It seemed to me that most of my clients understood that if you were the DCM, you couldn't be the QRC. But if you're still running into that, I think you just have to inform the insurer that they're wrong. Oops. This goes into this a little bit more as far as the QRC rules from the defense side, or the employer and insurer, asking about collecting medical records. Again, it's not your job, that's the insurer's job. It's not your job to make the treatment recommendations. That should be coming from the healthcare provider. It's also not your job to investigate the claim. From the petitioner side, we should be reaching out to our clients and asking the questions as far as what they're doing outside of work, past injuries, that type of thing. This first one I am guilty of having done or asked about. So if you were on any of my cases with this, I am now have learned this was not okay. But sometimes the insurer will ask to keep the rehabilitation plan open, even though the employee has been back to work successfully for more than 30 days until the treating physician declares the employee to be at MMI. I was informed that once the employee has returned to suitable gainful employment, the file should be closed. Even if the parties agree that the file should be kept open, Mr. Hill informed me that if he becomes aware of it, that will be a problem. So apparently once the injured worker is back to suitable gainful employment for 30 days, the rehabilitation plan should be closed, again, regardless of MMI, because you don't deal with MMI. The QRC going along with the insurer's request not to begin job search even though there are physical limitations and it's known that the employer does not have a job for the employee to return to work to. This just seems blatantly wrong to me. If the injured worker has work restrictions and the employer can't accommodate them, it seems to me that job search should commence. And if an insurer is asking you to do that, I would absolutely tell them no, and certainly you could report that to the state. And then for the QRC to call the healthcare provider to confirm the employee attended the medical or therapy appointment. It is not your job to call the healthcare provider. You can reach out to the employee, certainly, to find out if they attended. But Min Rule 5220.1801 sub 8 has 8B has the QRC roles and functions, and I'm sure you all have know them backwards and forward, but you don't have to contact the doctor to see if the employee attended the appointment. That is the insurer's responsibility. If the employer doesn't have a job for the employee to return to so that the employee will have to seek employment with a new employer, the insurer has requested that the QRC indicate on the rehab plan that the goal will be to return to work with the same and different employer, not just a different employer. It's my understanding that if the employee's restrictions are subject to change and the employer may have, and is anticipated that they will change, if the employer may have work available within those restrictions, this is something you can do, where you could indicate that the goal is to return to work with that employer or a different employer. But if it's known that those restrictions can't be accommodated, then the rehab plan needs to be returned to work with a different employer, and job search should commence. Another comment that came up was if the insurer requires QRCs to seek approval before attending all medical appointments, even if the rationale was already provided in the last monthly report and it's part of the rehab plan. I did see this quite a bit, and my understanding with the insurance companies is it was really a cost thing, that the cost of you attending and the mileage can be significant. That being said, if the rehab plan says that you're going to be attending all appointments, I think you get to attend all appointments, and if they have a problem with that, then their recourse would be to file a rehab request objecting to it. Certainly if you're willing to have the dialogue with them, you can do that, but if the rehab plan says you're going to attend all appointments, I think you have the right to attend all appointments. Annoyance that the QRC is providing services not on the rehab plan and billing the insurer for those services. This to me seems like a legitimate complaint that if you're providing services not on the rehab plan, that they could be frustrated if you're billing for those services. So it seems to me you should amend the rehab plan to include whatever services you're billing for, and then if they have a problem with that, then they could file the rehab request. All right. This one came up quite a bit in the comments as well. And in terms of full disclosure, have not dealt with this yet on the petitioner side, but I dealt with it an awful lot on the defense side. Once the Ewing case came down, we on the defense took the position that we didn't have to file a rehab request to terminate rehabilitation services. We could simply indicate that we were no longer approving the services, and then the onus was on you or the petitioner's attorney to take action. I think most often, if the case is already in litigation and there was a pleading pending, sometimes we would just amend that to include rehab. On the defense side, the strategy was perhaps trying to avoid a conference initially at the Department of Labor and Industry with a negative decision. If you receive, normally it's some sort of email or communication that says, pursuant to the Ewing v. Print Craft, easy for me to say, Craft case, our IME indicates that the employee has no ongoing work restrictions relative to the injury and ongoing rehab won't be approved. I think the recourse, if you get something like that, is to file a rehabilitation request on your own or reach out to the petitioner's attorney if there is one. If not, my contact information will be at the end here, and ask them to file a rehabilitation request, add it to the claim petition, any of those. So I don't think it's necessarily something we have to sit there and perform your services still where you're not getting paid. There are just actions that need to be taken. And I don't know if any of you are having experience with this Ewing case where you get the IME and they just tell you they're not paying anymore. So what do you do in those situations? Okay.
I'll tell you what's really obnoxious when you say the microphone. Sorry. I don't know if anybody else has had the experience where you not only get that they're denying everything, but then the defense attorney will go and ask you to do some stuff. Has that ever happened?
So the comment was that not only do you get the denial, but then the defense attorney asks you to go out and do stuff, and I'm probably guilty of that. And if I understood the comments, it was that you filed the rehabilitation request on your own or talked to the petitioner's attorney. So I think that's how the parties are getting around this, but I do think it's something that we'll continue to see because it's, as you know, the insurance companies don't want to have to pay for services if they don't have to. So as soon as they get those IMEs, those will be denied. I'm sorry, what?
I'm sorry, I just said they still want you to do the service.
Yes, and the comment was they still want you to do the service. So I don't know if you have any more questions. That's my limited spiel on the defense attorney and the petitioner's attorney. I will tell you that in general, I think the services you provide are really beneficial, and I felt that way as a defense attorney too. Not to say that I didn't try to deny your bills, because I'm sure I did do that. But now I will certainly try to get them paid.